Let's talk about the dumbest things that even smart criminal defendants do that mess up their cases and make things so much worse for them. I'll be going over 9 of those in this video. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, we are going to be going over 9 of the dumbest things that even smart criminal defendants do. And before I start, no shade to criminal defendants. You know, criminal defendants have the whole system against them, the cops, many times the judge, the prosecutor, of course. You don't need criminal defense attorneys telling you negative things about you. You don't need criminal defense attorneys coming on YouTube, or there's a lot on TikTok, like saying negative things about you. But a lot of these are avoidable, and that is why I'm putting them in this category of dumb. Number 1 is talking on the phone at the jail about your case, and even worse is if you call someone who is the subject of a protective order or a restraining order. And I know that this sounds dumb and obvious, but this happens all the time. And I think what happens is that sometimes people think, okay, well, it says this call is being recorded as you're going through it, as you're going through this call. But they think, okay, but who's going to listen to all these calls? They're all these guys. They're all on the phone. Who's really going to listen to this? Well, look, if you have a strike or 2 on your record, they're listening to it like almost certainly. If your case is serious, almost certainly. If it's a domestic violence case and there's a protective order, probably they are. They have a whole team of interns. This is the government. Of course they can listen to every single one. I'm sure that soon there will be, if there's not already, AI listening to them. So don't think, oh, they're not going to find this. It's a needle in a haystack. Definitely don't do that. Number 2 is talking to your cellmates about crimes. This is especially true if you were just arrested and you've not been brought to the county jail yet. You are still at the police station. They do what's called Perkins operations, especially for attempted murder, gang crimes, third strikes. They do these Perkins operations, which is basically where they plant people in your cell and they get you to make incriminating statements, and then they use that against you. And it is constitutional, according to the Supreme Court. I think that there are some big problems with it. I think that these Perkins operations may not stick around forever, but definitely don't talk to your cellmates about any case. And you may not know, they arrest you for one crime, and then the classic thing is that they set you up to talk about a different one. That's how they can do it. So just don't talk to your cellmates about any crimes. Don't talk to your cellmates and claim somebody else's crime either, because that could be a way that you end up getting convicted of something that you didn't do. Number 3 is, obviously we all know you're not supposed to confess, but the thing is that the cops they can be really, really compelling when they're trying to get you to confess. I've seen them, for example, say, we have your DNA. If you're truthful now, it's going to go a lot easier for you. Spoiler alert, it is not going to go a lot easier for you, and it could be that they actually have no evidence at all, and that as long as you don't confess, they're never going to get you for it. You don't know. But I think that when you're in this situation, you're really stressed, especially if it's your first time getting arrested, and you think, this officer seems really nice. He seems like he actually really cares about me. And, he's telling me he's on my side. He understands. He told me, the evidence is already stacked against me. They have me on surveillance video. There's nothing I can do except for tell him the truth. That guy's job is to seem like that. That is literally his job. He is going to go home and probably have a beer and laugh to his wife about how he got another one. Do not confess. It's not going to go away. He's not going to help you out. I've actually never seen, in my 10 years of doing this, any kind of criminal case where the detective is like, oh, you know what, be lenient. Where the DA said, the detective said, go easy on this one. That doesn't happen. So please don't do that. Number 4 is resist arrest or try to run or drive away. So maybe this isn't surprising to you, especially if you watch YouTube videos on stuff like this, but you cannot resist an arrest, even an illegal arrest. And I remember thinking when I was first an intern learning about this stuff, 12 years ago, I remember thinking, okay, well, it says resisting arrest here, but that's his only charge. What was he arrested for? We should be able to get this thrown out. You can't. So not on that basis anyway. So you cannot resist an arrest, even an illegal arrest. You cannot do not drive away, run away. I've had cases where, especially after all this stuff with Black Lives Matter and police officers shooting unarmed Black men, I had Black clients who are telling me, I was scared because they already were drawing their weapons and I'm just trying to drive away because I didn't want to die. That's not that much of a defense, unfortunately. You can only go so far with that. And yeah, maybe you take it to a jury and maybe the jury sides with you, but at that point you're taking a big risk. And I can't say in that situation, if you really think that you are going to actually be killed by the officer, I mean, you probably should run, right? You don't want to die, but that's not a defense, unfortunately. And I think that people think, oh, I'll explain this later, but, the explanation doesn't necessarily go that far with prosecutors or with judges. They mostly are on the side of the cops. It's not a legal basis to get it dismissed. So, ideally, you don't do that. I mean, if you are able to absolutely get away and they'll never know it's you, maybe you feel like that's worth it. Obviously, I can't counsel anyone to commit crimes, but I mean, when it's very obvious that it's you, they have your license plate, they're following you. Cops here love police chases, right? LA, they love police chases. That's like a great day for them. They love doing them. So you know that they're going to catch you eventually, and it's only going to make things worse for you. Number 5 is, unfortunately, stop paying your lawyer. Most likely, things are not going to go that well for you. I don't think it looks that great in court that, your lawyer is leaving you. Most likely, depending on how much work has been put into the case, you won't get a refund or not much of one, and we will leave the case, and then you'll end up with the public defender. I don't understand people who... I know maybe sometimes there are circumstances beyond your control and then try to work things out with your lawyer. Usually, they want to try to help you. They want to try to work things out with you there. But if you just sort of stop altogether, no effort is made, I always wonder, and I feel a bit bad, also a bit angry, but I sort of feel like you just wasted so much money though. Because if you would just, that money that you initially paid, I put in a bunch of time, I put in a bunch of work, and now, what are you really getting from that? Maybe we're almost to the finish line, and we're just not going to get there because I can't work for free. I have my whole firm that I have to make sure I take care of and, my own bills. So if you're going to end up with the public defender anyway, don't do that. If a lawyer offers you, a payment plan, and you're like, well, I don't know how I'm going to make these payments, I have that initial payment, maybe you just wait. Maybe you don't hire them right then. Maybe you see what the case looks like with the public defender. I wouldn't go past the preliminary hearing if it's a felony, but, maybe you just wait and kind of see. Maybe you talk to other lawyers that are cheaper. But I wouldn't just enter into a payment plan that you're not going to be able to make the payments for. Number 6 is fail to calendar court dates. So attorneys will remind you. But legally it's not our job to remind you. We will remind you, but you need to have it in your calendar. I've had clients who get a new phone or something, they don't get the text message, they never wrote it down to begin with, and then they're like, wait, I have court tomorrow, I didn't know, or they don't show up to court. And that's not what you want. Definitely if you're hiring a private criminal defense attorney, why would you then not show up to court? There will be a warrant. You'll look bad. Your attorney will be wondering where you are, calling you frantically. So don't do that. Failing to calendar deadlines for community service, classes, whatever you're supposed to do. So if you get some kind of deal where you're supposed to do something by a certain time, you need to make it your business to put that in your calendar. If you're watching YouTube, you have the internet, right? Use Google Calendar. Use whatever you need to, but don't forget. Don't just have some vague idea of when the date is. And I would get started on that right away if you possibly can. At least get enrolled right away so that you figure out, okay, how am I going to accomplish this? Do I have to sign up in advance? What do I have to do? Before you leave the courthouse, ideally, you figure that out. Number 8, and this one, of course, is obvious, and nobody's doing this intentionally, but pick up another of the same offense. So a common one is domestic violence. And this happens even in situations where I think that the person who's accused of doing it actually didn't do anything in the first place. I mean, there's obviously some kind of, well, in most cases, there's going to be some sort of strain on the relationship. And now, if somebody calls 911, even if it's a neighbor, it's not the other party, they call 911, and the cops come out and they look you up and they see that you were arrested for domestic violence, a few months ago or whatever, they're way more likely to make an arrest. Anytime you have criminal history, they're way more likely to make an arrest. So be very careful with that, especially, I also see it with, young kids that have a gun they're not supposed to have in their car, and of course it's confiscated. They have another car, another gun, now they get picked up on that, or they were on probation, which allows the cops to search you for the most part without probable cause, and they have a gun there. They're looking for you at that point, and it's so much more likely that you're going to get charges filed against you or get arrested if you pick up once you have a criminal record, even if it's just an arrest record. Number 9, and this one is it's laughable. You're going to think almost that I'm making it up, but I've seen it happen multiple times. Cut off your ankle monitor. So sometimes as a condition of your bail, you will have to wear an ankle monitor, but there are problems with them. Every client I've had who has had one, and I've seen numerous defendants in court that are always having problems with them. For example, you have to charge them for hours per day. It's a whole thing where you have to have good Wi-Fi. It's a big problem to have to wear an ankle monitor. Of course, it's much better than being in jail. I've had a client that had one that was monitoring if she had any alcohol in her system, and that was chafing her ankle. What you need to do, if you have problems with it, first try to deal with the service, get a new one. But if it's something you can't solve, like the client who had the issue with her ankle where it was chafing, and I saw it was bad, what you need to do is go into the court and explain that to the judge and find another solution. So for that ankle monitor client, we found a different solution where she had this device that periodically would require her to test her own breath for alcohol. There are solutions to these problems, but don't DIY and just think, well, I'll explain later. Cutting off your ankle monitor almost certainly means that you are going to jail, even if, you say, well, my foot was falling off. What you need to do is call your attorney, whether it's a private attorney or the public defender, call them and let them know the problem, and then they can go into court for you to address it. And then finally, so we've done the 9, but a bonus one that I always want to remind people of is call the police thinking that they are going to do something other than arrest someone when they come out. Thinking that they are going to mediate a fight for you, for example. That's a big one. That leads to domestic violence charges so frequently. If you have a loved one who is having some sort of mental health crisis, ideally you get that person mental health help, not necessarily call the cops. And of course, I shouldn't tell anyone not to call the cops if you believe that you're in danger, of course. But you have to know that when the cops come out, in all likelihood, they are going to arrest someone. They're not going to come out, do something, say something, and then just leave. That's not what they do. I hope that you found this video helpful. If you have a criminal case in California, feel free to give me a call. You can find my number down below, and you can also book a consultation with the link directly there.